Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder, leader of the healthcare practice at Roetzel and Andrus. I'm joined by shareholder Christina Kuta, also part of our healthcare group. Welcome, Christina.
Thank you.
Today, we're going to be talking about getting rid of patients from your practice. And Christina and I deal with this question repeatedly. But what we want to focus on today is why you would consider getting rid of patients, when you should consider getting rid of patients, and how you get rid of patients. And so I really want to start, first of all, by talking about some of the things that Christina and I witness in our practice clients where it becomes imperative and necessary to terminate a patient. So, Christina, tell me some of the examples that you've come across.
So yeah, and even recently, 2026 is kind of coming in with a bang for this issue. We've had a number of clients reach out to us with patient concerns. I can tell you that a lot of times we see this happen when there's been sort of a pattern of poor behavior with patients that are routinely abusive to staff, that are rude, disrespectful. They cause behavior problems in the office. A lot of times it's also patients that will, claim they're unhappy for a reason, and it's not something that's rising to the level of a malpractice claim or anything like that, but they're wanting the practice to give them services for free, or they're wanting the practice to refund money for certain procedures or services they've received. But it's usually sort of an ongoing pattern where the patient is not behaving in a respectful way or in a way that you would anticipate a person would behave in a business setting. And usually it's going on for some time before we hear about it.
Right. And I'm hearing the same things. And, I also want to mention, of course, that separate from behavior patterns, you have patients who don't show up for appointments, regularly cancel, don't follow the advice, contradict the advice that's given to them.
Don't pay their bills, they don't pay their bills at all.
Yeah. Right. So there's lots of different reasons to terminate, and those are the very obvious ones. And usually when a client calls us with those kinds of reasons, they're ready. They haven't paid the bill, they've done everything they can do to collect, the patient won't follow advice, et cetera, and those become clear. I think you and I struggle more where somebody allows a patient to come in and verbally abuse the doctor, the staff, leave harassing messages. And this sometimes incredibly goes on for a period of months or years. And the doctor allows the patient to remain as part of the practice. So as you can see, there are many different reasons why you might consider getting rid of a patient. So these are just some ideas. If you're not sure if you have a right to get rid of a patient, if you're not sure you followed the right steps before you get rid of a patient, you can certainly contact us. We're just trying to give you some ideas of what we have seen happen when it might lead you to really feel that you need to get rid of someone. Now, before we talk about the actual steps, I also want to talk about a growing trend, which is to have a contract between the practice and a patient about what the practice expects of the patient within the practice. So we have drafted these before, and we've certainly reviewed them before. What are some of the points that you're seeing in these kinds of contracts?
Yeah, we do see these contracts from time to time, and they are becoming more popular as time goes on. But generally, they're things like expectations set up for the patient, that you're not going to be disrespectful, you're not going to verbally abuse staff, you're not going to call continuously with harassing phone calls, you're not going to cause a scene in our lobby, you're going to appropriately handle complaints through the complaint process the practice is set up. It basically is sort of navigating their behavior and setting up expectations in advance for what the practice intends that relationship to be like. Also, they often have terms in them about social media, that you are not going to put, untrue information on social media about the practice. Look, if somebody didn't have a good experience with a provider and they want to share that, they're certainly allowed to do that. But what they shouldn't be doing is actually going on social media and lying about interactions, lying about a practice, lying about a provider. And unfortunately, you and I have seen that many times over the last year or so, where patients are putting up information on social media that's not just an opinion of their experience, but actually totally false information.
Right. Now, whether or not these contracts can be enforced in the court of law remains to be seen, but I think it does definitely serve as a deterrent to patients when they're reminded of what they agreed to. And many practices will have this sign on an annual basis, so it serves as a reminder. The other thing you and I have kind of talked about, and I expect to see this somewhat as a growing trend, is whether you can have patients sign something that if they do choose to go and post something false on social media, whether they are giving permission in the form of an authorization for HIPAA purposes for a physician or a practice to be able to respond to that false statement. And as many of you listening may be aware, typically physicians cannot respond to a statement made online, which puts them at an unfair disadvantage because a false statement can be made, but because you cannot identify someone as being your patient, you often cannot respond. And one of the trends we're seeing is that you can have the patient sign something that is a specific authorization for HIPAA purposes, that if a post is made, and perhaps this is, signed on an annual basis to make sure that it remains relevant to Google, Yelp, Instagram, Facebook, whatever it is, that sets forth a false statement about the practice or provider, that the patient is specifically giving authorization for the physician to be able to respond to that. And this is something that I think is the concept is growing in popularity. What are your thoughts on that?
Yeah, I mean, as you indicated, doctors are kind of hamstrung in that they cannot provide information in response to social media posts without really violating HIPAA. So having that authorization in advance that specifically says you are allowing me to disclose X information in response to social media posts during this particular window period, like you said, annually, and have that renewed, is a concept a lot of practices have explored. Now, there are some potential legal considerations. I'm not aware of any type of review of this by the bodies that enforce HIPAA. Would they see that to be valid authorization? Also, you generally can't condition treatment based on signing an authorization that is to the advantage of the provider. So there are some legal considerations that need to be further explored. But because this is becoming more common, I do foresee that regulators at some point in the future are probably going to address this specific issue.
Okay, great. All right. So we've decided there's a bad patient in the practice, making the doctor unhappy, making the people who work in the practice unhappy, and it's time to terminate them. So let's talk about what the proper steps are that should be followed. Okay. So what is step one?
So the biggest concern when we're talking about the steps to take for termination are to not have a claim of patient abandonment. So generally, you are not restricted from terminating a patient as long as you're not terminating for an illegal reason. And that would be a discriminatory reason, like based on someone's race or religion. But if it's someone's disruptive, not a good fit, not paying their bills, things like that, you can terminate that patient. The first step, I think, goes even before you decide to terminate, which is documenting everything. If you have a disruptive patient, if you have someone that's not paying their bills or someone that's really causing problems in the office, you should make sure that that's been documented. So you have a history and support for that. The next step is providing written notice to the patient, offering to forward their records to a new provider in compliance with HIPAA, and making sure that you leave a period of time where you're still available to the patient to prevent claims of abandonment. We generally recommend refilling prescriptions for 30 days. If a patient's undergoing treatment that must continue for a period of time, it's ongoing frequent treatment, continuing to care for that patient for at least 30 days. Depending on their illness or what type of treatment that patient has that may need to be longer. Also, depending where you live, if you live in a more rural area where it might be more difficult for someone to find an alternate provider, you may need to require more time or be available for more time to a patient in order for them to provide to receive care from someone else. But the main issue is you want to prevent claims of abandonment. So just saying, I'm terminating you today and I'm going to have nothing to do with you after today is likely problematic unless it's somebody who isn't on medications that you're prescribing for them. It's not somebody that has any ongoing mental health issues or physical health issues.
Okay, perfect. So getting rid of the patient technically is easy. And of course, I just want to kind of make it clear that if somebody is posing a threat to your safety or to safety of someone in your practice, you certainly, can review whether you have to continue to interact with that person. So the 30 days is not a hard and fast rule if you feel your safety is at risk. When you terminate someone, even if you follow all these appropriate steps, that does not necessarily mean the harassment is going to end. They may continue to show up at the practice. They may continue to send letters. They may have their lawyer send a letter. They may threaten you in other ways. You will need to do what you need to do. Certainly, again, if somebody's showing up and they're not authorized to be there, you can always call the police and make a report and document that. If you're continuing to be harassed in other ways, we always invite you to provide our name and contact information. Usually the minute a lawyer's involved, somehow, they disappear or they quiet down. If you're doing things legally, you're properly terminating them and it's a proper reason, they can make a lot of noise, but it should not have any bite at all. And but just want to let people know that it's not necessarily the end of the road once you get that letter out. You agree?
Yeah. Yeah, absolutely. I would say 90% of the time it is, and people will go away and they'll find a new provider and nothing else happens. But there is that 10% of patients that will continue to make a lot of noise, and whether that's going on social media, whether that's filing complaints, whether that's continuing to contact the office by letter or phone, that does happen. So you should always be prepared and sort of have a process for handling that. I also want to note that state medical boards may have different rules or recommendations regarding terminating patients. So you always, if you're not familiar with them, you always want to, take a look at what your state medical board says about terminating patients to see if there's any additional, things you need to include in a letter or things that you need to consider when doing that.
Right. I agree. And then finally, just the last point I want to make is don't hesitate and wait too long to terminate a patient. If you're seeing all the red flags, you don't need to give them chance after chance after chance. If they've already extorted you and you've refunded money and you've redone it and you've already dealt with them and their lawyer and you don't have to keep someone as part of your practice who's making you miserable. One of the most shocking things to me is how long doctors will allow a patient to be abusive and to behave badly before they're willing to terminate. I know it's that sense of wanting to take care of people and not wanting to abandon patients, but I do think more often than not, doctors need to act sooner than they do.
Absolutely. And I think sometimes there's also a concern that if I let this patient go, they're going to speak badly about me. They're going to tell lies about me on social media. I'm going to get a bad reputation. And I'm really sensitive to that. But I'll tell you, whether you terminate, if a patient is the type of patient that would do that, whether you terminate them the third time they do something versus the 20th time they do something, they're going to do it anyway. So save yourself the heartache and don't continue to take abuse or have your staff continue to take abuse. Terminate the relationship, and then there are ways to deal with patients that may cause trouble after that relationship's terminated.
Great. Well, great advice. And this has been the Health Law Hotspot. Thanks, Christina. We hope you'll join us next time, and you can check out more of our podcasts at ralaw.com. Thanks for joining us.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.